It is Tuesday, April 7th. Another Hot Topic Tuesday. Thanks for jumping on. Everybody was actually pretty early, so glad to have you on board. I've got some preset things that we'll call it, it's kind of like the hot topics for 2025 almost. Some things are going to be, I think, fairly simple, fairly obvious, and other things that could create some good discussion points. Along with that, if you got some of your own, bring them up. Let's talk about them as we go along. So, here's what I've got for us on the first one. Simple, but the question does come occasionally. Is a real estate licensee no longer responsible in connection with the closing handled by a title company? Otherwise, can we wash our hands free of making sure that this transaction is closed appropriately? What say you? Marietta's giving me a little head shake. Yeah, guys, it's still on our shoulders. You see, in reality, a title company is closing this under our direction as a brokerage. So, as a licensee, as a broker, we're still responsible, even though we're not signing closing statements. That's not a requirement anymore. We're still responsible to make sure that it is closed in accordance to the terms of the purchase agreement. Who knows that purchase agreement and the terms better than anyone? You do. So, we had a session earlier, a hot topic that kind of addressed this and the importance, and I think it was right at the first of the year. We've got to make sure that not only we check it, but that our managing broker are checking the files prior to closing to make sure that one of the biggest ones for us is that we get paid and that we get paid the appropriate amount. And we had one of our agents, now I'm sure there's more than just the one that I knew about, but we had one of our agents that missed out on 0.5% because the title company didn't see how much they were supposed to collect. Ouch. So, bottom line, yes, we are still the ones fully responsible for how that works out. Does a home tour agreement automatically establish an agency relationship? You know what we're going to do with the next one on these? I got to set up a poll. We're going to do it that way. Does a home tour agreement, even if I generalize it, no, I'm going to leave it at that because it kind of goes into the answer. I think most of you know it doesn't necessarily establish an agency relationship. In the state of Michigan, we all know because we've talked about this plenty, implied agency. Through our words and through our actions, we can imply agency. 100% of our fiduciary responsibilities. What does that buyer or seller owe us when we imply agency? Zero. Nada. They owe us nothing. So implied agency is not a good thing. It can happen, but it's not good. So here's the key. We need to make sure that we're disclosing our agency relationship in writing and accompanying it with the buyer broker contract. People have asked, well, why don't we have the home tour agreement? Well, if you go tour a home with someone, how much do you get paid with a home tour agreement? Typically, there's nothing and no place for you to be able to get paid. So the buyer has no commitment to you. You have the risk that you might do or say something that could imply agency. So there's just too much risk, is the way that we've come to look at this. What we did with our buyer representation contract was, look, I'm only going to show the home to people who are willing to pay me if they buy that home. So our buyer representation contract is set up in such a way to cover these individuals, so that we're going to ask the question, well, if I were to show you this property and you decided to buy it, would you make sure that I get paid? And of course, we need to know how to keep that simple and help them understand that we just simply build it into the transaction by asking the seller to pay it. And then what we would do is we would put the individual address or individual addresses of the homes that we show them that day. They're only bound to pay us if they buy one of those homes. Questions there with this one? Everybody's good? Grosse Point, you can give me a thumbs up, you guys. There, yeah, even 2 thumbs up. I appreciate that. All right. Oh, Danny, you're awesome. I like it. Okay. So here's the biggest thing. It's about getting paid. So ensure that you get paid. And how do you get paid? By having a contract signed. I don't know that it's quite worth it showing a property if we're not going to get paid. Here's a simple one. Are we still required to carry our pocket cards? Marietta's giving me the head shake yes. Guys, what do you think? This digital world, are we still required? Yep. By law, as a licensed real estate individual, we are still responsible for making sure that we get or have on our person. Ladies, it's okay if it's in a purse. Yeah, Roger, you probably could get by with a digital copy of it on your phone. But just typing your number in probably wouldn't do it. So you know what? I think that would probably work. But what's the best way? Just to have it with you all the time. I'm closing in on 39 years. 1987 was the first one. I have never been asked for my pocket card, but that doesn't mean we can't have it on us. And the key would be is if somebody said, by the way, do you have your pocket card? Well, yes, I do. Here it is. And I don't know. I don't know why the law says that we have to, but we do. Yeah, go ahead.
Oh, they didn't send me one last time I renewed my license.
I would check with I can't remember who's at your front desk, but anyway, check with your admin
Oh,
because typically they do get forwarded to the office. Sometimes
oh,
it might not get to you, but check there because I wouldn't doubt if they do have it along with potentially your wall license. The one thing that did change was that the broker no longer has to display prominently all of the wall licenses. But we as the agents do still need to carry our pocket cards with you. And again, I wish I had the rationale behind it. I don't know what it is. 39 years, I've never been asked for it, but I don't want to have the opportunity when it finally comes up and I don't have it. Good, good, good. Okay. Um, I think we got all of those questions answered. So moving on. Here's the next one. As a real estate licensee, am I still required to disclose on a purchase agreement that I am licensed when offering to purchase a property personally? Yeah, I think that one's pretty obvious. It's more to the point of when I'm related to the purchaser. The answer is still on that one, yes. So even when I'm related to the person who is purchasing, I still must. And as I put it, doesn't quite make sense to me. never has. But in the case of the purchase, clearly the occupational code says, yes, you must. And the best place to put that is on the purchase agreement. That way you have a signed, uh, uh, what do I want to say? It's on the purchase agreement, which because we are to make sure they are aware of it. Even a cousin. I don't think it has to go to the point of a cousin. I think it's really just immediate family. I've never quite understood it since we started with agency disclosure because what does it matter at that point? I think the biggest thing is, guys, if you're going to purchase a property personally, not only would I disclose that I'm a licensed real estate agent, but I would disclose my intent. Picture yourself going out talking with a seller, and the seller's in a big hurry, and you say, well, let me ask you this. If I could get you this amount tomorrow, would you take it? And they say yes. You're now going to write up a purchase agreement. You're buying it for less than what its actual market value is. Would it not be good to have something signed that says, I am a licensed real estate agent in the state of Michigan. It is my intent to turn around and sell this home for a profit. It's now disclosed why I'm doing this. It's hard for them to come after you with well, you didn't tell me that it was worth this. So whenever you're buying a property personally, I'd even add in, not that I am a state of Michigan, although I need to state that I'm a licensed agent state of Michigan, but my actual intent. How about with a partner? If you are part of the purchase, that partnership, if you are a significant other, I would disclose. I just think, there's when in doubt, disclose, disclose, disclose. It's the safest way for us to be able to do that. So a partnership in the business or just a partner, when you have that tight of a relationship, I think that would be something that would make sense. If I do not yet have an agency relationship with a buyer, can I show them a home without a written agreement? I see head shaking no. Is there a time when I could show a buyer without a written agreement? There we go. Only if you are the listing agent. Another way to be able to clarify that, only if you represent the seller. So no, we can't show it without it because the settlement requires that a realtor is working with a buyer touring homes must have a written agreement in place. A realtor who is not working with the buyer, or let me rephrase that, they are considered not to be working with the buyer when they're representing the seller, when they are the seller's agent. I almost wiped out sub-agent because we don't do sub-agency. However, I've got Erica, who's out there at the Shelby office, which is Century 21. I got Harry, who's over at Coble Banker. Erica says, man, I'd love to hold open your listing over there on, Harry, if that would work with you. We're game to that because we're the same company. However, Harry's at one of our brokerages. Erica's at the other brokerage. If we were to do it, I'm not going to say the right way, but the easy way for Erica to hold that open and not have to go, well, before you come through, you got to sign this agreement. She would have to be a sub-agent. It's the only time that we will do sub-agency. is within our own umbrella. And that's the only reason I left that part on there. Now, I don't have everybody's faces on there, but if that you're going, you got to let me know because the faces I see, I think everybody's good with that. Check and chat. Everybody's good. It is important to note that an agent who is a dual agent or a transaction coordinator is working with the buyer. I think that makes sense because you can't be a dual agent unless if you represent the buyer and the seller. Everybody good? Wow. I must have written this out so well. All right, here's another one. This one is kind of fun. So, if my seller received an offer with an escalation clause, everybody's familiar with that, and the highest offer that the seller received was contingent upon the sale of a buyer's home. Everybody with it? Everybody's good? Does that offer trigger the escalation clause, or must it be disregarded because of the contingency? Yeah, now we. Well, guys, as a broker manager, here's the first thing I always said: give me the paperwork. I need all of the paperwork because what's going to make the difference is what the paperwork says. So let me give you this off or this answer first, and then we'll see if we can discuss further. The offer with the home sale contingency would not be disregarded unless there is language in the escalation clause that says so. So my heads up on this is to make sure that when you are using an escalation clause, you're writing it representing your buyer. Matter of fact, I think it should be done if you get one poorly written or weakly written or it's about a sentence long. Make it fit, or if you can reduce it, um, do what you have to do to be able to use it. But here's what I want you to do. Make sure you use the clause. Ours will actually state that it's a non-contingent. State. So as Brenda put it there, the PA rules completely. How's everybody else doing? I see Marietta lost hers. So it must have been me if a couple of you got it. Well, I haven't got notice of my internet being unstable. So, um, did you miss much of anything when it kind of froze up?
Mhm.
Okay, so let me just kind of go back and review a little bit because the key part of it is on here. But what I want you to remember, wow, volume, interesting stuff. He's good, lights on. I'm not freezing here. All right. Well, let me know, guys, if. So let me just kind of do a quick review for this. Um, it's the paperwork that rules. What does the addendum say? What does the purchase agreement say? I'm going to say most likely if there's an escalation clause, it is on an addendum. Make sure you use what we have put together because it's extremely thorough and it will keep you out of courts because it does a whole lot of the, well, what if? It gives very clear understanding as to how it works. Lydia, you might have to come out and just ask that question because I don't quite understand what you've got here.
And my mouth is full. So I don't know that I would lean toward a PA that had a house for sale.
I would tell you that I am. Well, let's address it from a separate point. If we don't have multiple offer, would I lean toward a home that, let me rephrase that. Would my seller lean toward a home that is contingent upon or an offer? Let me put it that way. Would my seller lean toward accepting an offer which was contingent upon the sale of a home? The answer could be yes, but how do they do that? What's the way that they're really going to consider doing that? Show me the money. So a seller is much more likely to accept an offer when it's worth accepting. But is it a realistic offer? Can they do it? Because what happens when they accept an offer which is contingent upon the sale of a home? What happens to showings?
Yeah, the showing stop when you're not open to any other offers. So that's why I would
Yeah,
not lean toward
yeah.
anything that had
So
a house.
that's where, when we then, Lydia, with that thought in mind, bring it over to now we've written an escalation to a purchase agreement. And our offer is competing against one of these where it is contingent upon the sale of a home. Do we want that to kick in the escalation clause and now all of a sudden our buyer is going up to the top? And the answer is no. So our escalation clauses are written so that we are not competing against those. You may remember, gosh, I don't remember when it was, but within the last year, we had a conversation of an agent that I know who wrote a very simple escalation clause that I think at least both real estate agents were understanding what was meant to be interpreted from the escalation clause that she wrote. In the end, the buyer didn't interpret it that way. The appraisal came in far, well, was an escalation clause. It was more of an escalation than an appraisal guarantee. And it really got kicked with the appraisal guarantee because it was misinterpreted. It was not written in such a way that it could be or would not be misinterpreted. And they went into courts and it cost all the parties a whole heck of a lot more than what they would have actually had, but just a mess because it was a simple appraisal guarantee. We got to be careful with any time that we're doing something like that.
Also, if there are no other offers on the table, why would I even entertain it?
Well, so if we stay off of the escalation and just go with why would I entertain? Well, and again, I want to rephrase that. Why would my seller entertain an offer where it is contingent upon the sale of a home? So I would tell you that, Lydia, you and I are on the same page. I don't like them. When I'm representing a seller, I don't like them. Because my question is can you buy it without selling your home? If the answer is yes, then make me an offer without having it contingent. If you can't, why would I ever give you any additional time to get lucky and sell your home? So I would take one, but I would not accept it with any time for them to remove it. Now that's representing the seller. As a buyer, well, look, if there's somebody else who doesn't think the way I think, a seller who's willing to go ahead and take the risk, maybe it's a seller that's been on the market for 90 days and their agent keeps going, you got to reduce the price, got to reduce the price. And all of a sudden an offer comes in at their asking price, even though it's contingent. They might say yes to that.
Yeah, but I'm thinking that this is the one where we're talking about an escalation clause.
If
Why
it's an
would I?
escalation, and again, if it's an escalation clause as a seller, I'm going to use it. I'm going to use it to have your offer escalate to the highest amount.
But we're talking about no other offers. If there are no other offers on
Well,
the
again,
table,
but you so if there's no other offer, then the escalation clause doesn't even take effect.
okay.
This is what if there were multiple offers and I'm writing one with an escalation clause. You see that I want to make sure that's included, but at the same point, I don't want my buyer running into a competing offer that is contingent upon the sale of a home, which has been written higher because it is contingent. That's where the escalation clause will save you should you use the one that we've got.
Got it. So in answer to this question that's on the board,
Uh-huh.
I would not lean toward that offer with the house to sell.
Well, again, it's not me or you, it's the seller. I'm going to go seller. Let's simplify it. There's two offers. Here's one, here's the other. Here's the bonuses to this, the bonus to this. Here's the negatives, here's the negatives. Which one do you want to work with? It's up to the seller. But me, no, I don't like, from a seller's perspective, I don't like contingent offers. Contingent on the sale of a home.
Hey,
I
Darwin.
think I think we're thinking the same way on it. But go ahead, Marjorie.
Yeah, just a quick comment. And I don't know what those mortgage programs are called, but I know that sometimes a buyer can qualify for one of those special programs that's being offered by a lender that allows them to,
Mm-hmm.
um,
Yeah, the bridge loan is the old common term for it.
okay, yeah,
Yeah.
yeah, yeah.
And that's sometimes that's the best way to do it. The
Mhm.
only problem is, and an individual needs to be aware of this. It's a great thing unless if the market tanks on you, or if
Okay.
the market begins to fall, or
Mhm.
if instead of it takes a month, now all of a sudden we hit a slow part of the season, and they hold on to it for another 3-4 months. I just had one. They didn't want to catch me in regards to realistic pricing up front. We did it in the fall, so now we had the stagnancy of the fall market into the winter. 5 months before we closed on it, and they had two payments. So it's just one of those that we have to talk with them, guide them, make sure that they're making great decisions. At least I should say informed decisions. My case informed, but it took them a bit before it was like, Darwin, tell us what we need to do. We went our way and didn't listen to you before. Our ideas didn't work. And that was literally, he said, our ideas didn't work. Tell us what we need to do. We made we talked, made a price adjustment to where I said it needed to be, and it sold 1 week later. All right. Moving on. If a seller slash client, now this one's a bit, because I was looking at this and going, what is the right answer for this? Who the trustee of a property is owned by her parents' trust in which she currently resides, is she exempt from the Seller Disclosure Act? I see a couple of no's. I see a yes. Oh, there's some more no's. Okay. Why is she not exempt?
Because as a resident of the household, she has some knowledge as to the workings of the property.
Miss Brenda, you're really close on that, but there is a specific term. And it is a non-occupant fiduciary. So she's occupying the property as a trustee.
Mm-hmm.
So it's not just that she has the knowledge, but it's that she's occupying. And what caused me to go, gee, what is the correct response to this one? Let me give you a scenario, and I'll use Miss Brenda here. So Miss Brenda is the only child. Mom and dad have passed. She's been taking care of mom and dad for the last 10 years, everything in regards to the house. She's paid the bills. Something needed fixed. Brenda was taking care of it. Mom and dad didn't have to do it.
Well, she would be a non-occupant, but she still has knowledge of the workings of the home.
But you would not be responsible for disclosure because now you're a non-occupant. So, and that's why I was saying you're really close, but there's a significant difference. It's non-occupant fiduciary. So even though in the scenario that I created with Brenda, she has all of this knowledge, she would still be exempt because she's not an occupant of the home. Now, might she want to disclose? She may want to. Am I going to tell her she's required? Nope. I'm going to show her and have her initial a form that says she's not required and then leave it up to her after a discussion about whether or not she wants or needs to disclose. But this is one conversation I've had with Jack Waller and Rick Linnell, and there was kind of a non-agreement. Now, it was a couple of years ago when I brought this up, this scenario. One of them said, well, I would. And it's exactly, Brenda, what you were saying. They have knowledge. But the other one was in the point where it's like, well, don't know that I would ever have somebody require someone to sign or fill out a disclosure when they're not required to. So from their perspective of that situation, not a real clear answer from two dudes that know real estate law.
I don't think I would require that non-occupant to complete the disclosure. No, I wouldn't do that.
Yeah.
But
I agree.
I would think that there's a good possibility of some legality if they have knowledge of the home and do not disclose it. It seems that that buyer, if there's an issue, may be able to start a legal action against them.
So what do we call that term? What's the term where if it cannot be seen, cannot be found, cannot be discovered, yet you have the knowledge? Material defect. Material defects, when known, must still be disclosed. So even a non-occupant fiduciary who's exempt, if they have knowledge, they must disclose. The one that I always used is a furnace with a cracked heat exchanger. That's emitting nasty fumes into the home that's going to kill somebody. We must disclose. in a case like that because it's a material defect.
Going to show up in title anyway. I don't know why people would dodge not disclosing that.
Well, that wouldn't, because how is the title going to know?
Well, sometimes when it's in a trust, doesn't it require a little bit more steps in order for the sale to be approved? Like a trustee, doesn't somebody?
Well, a trustee, that's what we actually have. So in the scenario I created, Brenda would be a trustee. It could be a court-appointed trustee, and
Right.
they may not even know because they just got it and said, here, you got to take care of this, get this property transferred, settle the estate. So they may not know. So again, if it's a known material defect, then a seller must disclose that. But it's not recorded anywhere to where a title company would actually have that information. Okay. Good stuff. Good stuff. And again, this is what I'm looking for. So keep participating, guys, because it's how we learn. Because the answers are not always overly obvious. Here's the next one I've got for you. This one happens. And this is one that I've had multiple times over the years. And when you know the answer to this, it's a whole heck of a lot easier to deal with it when it comes up. So the seller accepts a purchase agreement. It is signed. It is bottom line. We have a binding agreement with buyer A. Even though the purchase agreement said, well, you're not going to present any other offers. Well, when I receive them, I don't have to present it based upon our paperwork. However, there's times when somebody's going to say, well, no, I don't agree to that term. I want to receive all offers. I'm not going to lose a listing over one term in the contract says we're not going to present any offers. So let's say it happens, or more importantly yet, what about when you're on the other side of it and you happen to be buyer A? So look at it from both sides now. Buyer B comes along, makes an offer that is actually higher, better, and acceptable to the seller. Wow, this is fun. Buyer A does their inspection, presents an amendment, and you name it, requesting something be fixed, that they'll reduce the price, you're going to leave the pool table, whatever it may be. The seller then says, well, wait a minute. That terminates their contract. We're going to move forward with buyer B. If you're in this for any time at all, you're either going to have a seller who's going to want to do this, or a buyer B that's going to claim that they can be cut. But normally it's a seller. Okay, you're going to have a seller. Either you represent them or you're going to be on buyer A's side, I should say. And you're going to get this call. And you're going to be confident in saying, no, that is not what happens. It is not dead because I proposed an amendment to the purchase agreement. So does buyer A's proposal of an amendment to the existing purchase agreement reopen the contract in such a way that the seller can terminate it? And all of you are shaking your head no. That is a misconception. Our case, all we've got to do is turn to the inspection contingency. And there are 4 options, of which one of them says, if we cannot agree, then the buyer may elect to move forward the purchase agreement as it is written. But it's the buyer who has the option. But let me give you the reminder again. What's the paperwork say? Because that purchase agreement is what's going to rule. So, no, there is no declining A unless if A walks away. Seller cannot declare it dead. Very, very clearly, especially with our purchase agreement. But what's the purchase agreement say? Most of them are going to read exactly the way that we are talking about it. A seller can't rescind it just because there was an amendment proposed.
So if you don't want to accept whatever the proposed amendment is, and you tell that to the buyer,
And now the
the buyer,
buyer has
then the
that
buyer has to
choice.
say yes or no.
You got it. Because the buyer can go ahead and take the fourth option, our purchase agreement, take the fourth option and just
Okay.
decide to move forward with the property as it is under the terms that they've got accepted. Okay. Yeah, and Lisa, that's pretty much what you just put there. The seller can just simply refuse to do the anything on the amendment, whatever was proposed on an amendment, but it still ends up for the buyer to decide whether or not to move forward. They have that option. So I would strongly encourage you, if you don't know very specifically those four options, you should take our purchase agreement and study that, because it will help you to negotiate in a very, very strong position when you know it and understand that. Everybody good there? Looks like I got everything. Everybody's good. Moving on. I'm a buyer's agent on a for sale by owner. Now, this one you guys should be familiar with, but I thought I'd throw it back in here just in case. The seller refuses to provide a seller's disclosure statement. What can be done? I'm going to put it this way. What are the buyer's options? Well, here's what we know from the last time I brought this up. Even though by law it is required that they disclose, they're a qualified one because it's 1 to 4 family residential dwellings, seller must disclose. But even though it's required, if they don't provide one, here's what the law says. And yep, Danette, you nailed it. The buyer can back out anytime up to the time of closing. So buyer's really in control. But here's what they know. Do you want to walk away simply because the seller wouldn't disclose? That's why we do inspections anyway. But it's still in the hands of the buyer. Buyer, I can't get one from them. They're not going to provide it. Here's your option. Do a very, very thorough inspection and decide whether or not you want to buy it. And the only thing it really does, the inspection, they can remove that, but the buyer can still walk away up until they've signed the contract at the closing. Signed all the documents, I should say, at closing. So I'm going to leave you with that, guys. Do you have others that you would want to discuss? Other situations, circumstances. You guys are making it easy on me today?
Hey, Darwin,
Yeah, go ahead, Don.
can you go back to the open house scenario again?
The open house, did I have one specifically for, not necessarily for that, but it was
I guess that
the,
was the example you gave. It
yeah,
was
that was,
page 6 yeah, there you go. Can you revisit that second paragraph again?
a
Just
realtor is not working with the buyer if they are interacting with the buyer representing the seller. Simplified. If you represent the seller, you are not required to have a written contract, which is why with the open house, we're going, well, again, we throw it in. I'll throw this too. Remember that how you do this has been left up to branch managers at this point. As the listing agent, I represent the seller. I hold an open house. Come on in. I should, by the way, at that point, be going, by law, this is the agency disclosure you're going to see here that I represent the seller, sign there. By law, not terms of a settlement, by law, that's what's required in the state of Michigan. Have any of us done that? No, we have not. But by law, that's what we're supposed to do. But what we don't have to have is a signed contract with the buyer. Why? Well, if that buyer walks into my listing, I hope I've written a listing agreement that I get my full compensation, taking care of both buyer and seller. So I don't need an agreement, and they were smart enough to go, you can't force a buyer to sign this and take away and force a seller to accept dual agency. Now, that's what we do with our contracts. But the government can't force that. They were smart enough to realize that. So now, Don, if you were to say, hey, Darwin, I'd like to hold your home open. We're in the same brand under Coldwell Banker. Even though I'm in Lake Orion, you're in Fenton, you could hold my listing open and you have an option. You can be in a situation where if somebody walks up, you have to go, before you are able to tour the home, I need you to sign this contract stating that I represent you and that you're going to make sure that I get paid my 3%. And they can't come in the house until they've signed that. Is that the way you want to start a relationship?
probably
So
not.
then what you and I would do, Don, is we're going to go, okay, hey, seller, I'm appointing Don Swain, who's out of our Fenton office. He also is representing you. He's now designated. Well, now, hi, I represent the seller. No need for a signed contract. So, Don, the other scenario then that I put in the reason of the sub-agent, if I was at our Clarkston office, I'm now Century 21. You're Coldwell Banker. Two different brokerages. Technically, the only way that you could do that is then to come in as a sub-agent.
Gotcha.
My whole point to everything was that's the only time that we'll allow sub-agency. It's because it's under our company umbrella.
Right. So in that first scenario you said where we're both with the same Coldwell Banker, is there any update or is it just verbal that, hey, this agent is designated, or is
Well,
there?
I'm going to throw it to you this way, Don. You're going to get with Mike and Alex and see what the office
Okay.
policy is.
All
Okay.
right, fair enough.
As a minimum, I would send an email that shows that you have been designated. Okay. That would be a minimum if we're going to do it that way. But what would be the best? Send the form over, having them sign and acknowledge it. Okay. Good question.
Okay, thanks.
I'm going to do the slippery slope.
Oh, she's going to go there.
So we know that because I'm working with an agent from my office, I know the side was doing the 6, 3 and 3. So I'm like, what's the harm?
None,
Okay.
none. Um, and that's exact. And Lydia, you really simplified it. Yeah, and this is me. I don't overly get into the aspect of do I have any concern with Lydia representing my seller? No. Even the aspect of, well, could I have Lydia designated for that day only? Yeah, but when does her duties end? They don't. So her confidentiality, if she learned anything about my sellers, goes on. We're really just talking that it's the legalities that we've got to deal with because am I really going to go, hey Lydia, just so you know, the sellers are already moved out. They're down there. Good Lord, they gotta have their money in 15 days. Am I going to tell Lydia all that? Nope. So does it I'm going to say that really it's just covering our backside. But what Lydia's got to remember if she ever brings a buyer to this home now, whom she represents, what has she become? She's a dual agent, guys.
Dual agent.
Yeah, she's a dual agent. Yeah, so Lisa, thank you. Nobody actually said this. Well, sometimes a buyer doesn't want to sign a buyer's agent contract. So, Lisa, you might have to come out and participate with me on this one. Why would a buyer not want to sign a contract? And we all know this is true. Why would a buyer not want to sign a contract?
Sometimes they just play in the field or just being, I don't know. They think that they'll get a better deal if they go directly with the list agent,
Yeah.
or they only want you to show them that one house. They don't want any parts of being connected to anyone.
Yep, exactly. It's like, well, I don't want to get tied down to one. There's a lot of different reasons, right? But if
Right.
we know what all those possible reasons are, then we can handle it. So, you ever heard the term that buyers are liars?
Yes.
Well, how about buyers are liars and sellers are too? Okay. I'm going to say it's not that buyers are liars and sellers are too. It's that as realtors, we don't ask enough of great questions. One, we probably don't ask enough questions, period. But number two, we don't ask enough great questions. So anybody can jump in. Let's do a little role play. Lisa, you're on the hook first, though. So, Lisa, I can appreciate you wouldn't want to sign a contract. Would you mind just sharing with me why you wouldn't want to do that? Throw
I don't
one
want
out.
to be I don't want to be tied down to one agent.
Okay. Geez, you know what? I can appreciate that. I would definitely take a look at what my options are and working with one or being able to work with many. Is there anything that you realize or that why you would want to work with a whole lot of agents and have that opportunity?
I was told you could get a better deal if you work directly with the list agent.
You know what? I've heard a lot of that too about getting the best deal. I'll tell you what, for now, let me ask you this. If I were to show you this home and you were to like it, would you make the offer on it? Say yes.
Yes.
Okay. And if I did, would you buy it from me?
Yes.
Okay. So I'll tell you what, why don't we do this? Let's just set it up so where I show you this home, I get paid, and you get great service. And if you don't, well, look, I'd always like to interview for the job of helping you buy your new home. But would it be okay if we just put it down and we only worry about this one home?
You could do that.
Because if you went, no, I wouldn't buy it from you. Am I going to show it to you?
No.
No, well, who are you working with? Well, I'm working with Don Swain. Well, I can't believe you would do such a thing, but if you're going to buy it from, just kidding, Don. But if you're going to buy it from Don, just call him, let him show it to you. But I'm
Yeah.
just curious, why did you call Don in the first place? Well, I can't ever get a hold of him. He's always out gallivanting around the country. Right? Who knows? right? But the bottom line becomes this. If I were to show it to you, are you in a position where you'd be ready to buy it? Well, yeah, as long as it works out. And if you were to buy it, would you buy it from me? Well, yeah. And you wouldn't have any problem making sure that I get paid, right? Well, yeah, but didn't that get kind of paid by the seller anyway? Well, we can definitely make it work that way, so let's do this. I don't mind. I have to have you sign a contract because that's what the government has forced you to do. I can't show you the home without you having signed a contract. But I don't want you to be committed to me on everything that you look at from this point on. But let's do it just for this one house. That way, you get in. You and I have lived up to what the government tells us we have to do, and we're both covered. Fair enough? It's the reason our buyer representation contract is written the way it is. And the reason that we, again, don't have the, what do they call it? Home agreement or, yeah, showing agreement, whatever they called that originally. Good question. Glad we went back to that one. What else you guys got? What have you struggled with? What are you having battles with? Yep. All right. That
I
was
have
the
an
7 second.
interesting.
Oh, go with it, Danny.
Okay, I had this past week I have two buyers and they both wanted to put an offer on the same house.
Oh. And you represent both.
And I represent both. What do you do?
See, guys, this is where it gets tough. The contract allows for it. So essentially what the buyer's done is they said it's okay for you to be a dual agent. Not in what everybody refers to as a dual agent, although we're representing two or more parties to the same transaction. So you show it to them and you hope that one of them doesn't like it. Well, then you run into they both like it. Well, you hope that one of them don't like it so much that they won't make an offer. But then they both like it so much that they both want to make an offer. And that's what you're talking about, right, Danny? So what do we do? Well, one thing is to know the paperwork allows it to happen. And it tells them. So go back to the buyer representation contract and read this particular paragraph. I can't quote it off the top of my head. But it's there, and it says you can do it, and that you can write both offers for both parties. But it's a nasty position to be in.
Yeah.
So I might go to my buddy Jack, who's in the office, and say, hey, Jack, can you do me a favor?
Yep.
I'm in this position. Can you work with this person, put the offer on paper? I've got this other buyer writing on it, same thing. I'm going to take him to dinner, give him a gift card for his time. Keep going. But, Jack and I will come up with an agreement for his time, and only one of them hopefully gets accepted. And I'm able to hold on to another buyer because it's just an unfair situation. It's not fun. I think I've run into it one time.
I
Biggie
did just
is
that. I
treated.
did.
Go ahead.
I did just that. And luckily, they didn't both put an offer on the property. In the last final thing, they didn't. But
And
Val
yeah, when
was
you got
gonna
down to
pick
it, only
up.
one.
Yeah. It's a hard one. That was a hard one.
Yeah. So, Lisa, great question. Does Jack write it in his name? Well, Jack probably would, which is really why I wouldn't go to him. I'm just kidding. No, Jack, if you think about it, whose offer is it? It's the buyer's offer from Danny. Jack just jumped in to be able to help with it. If we were doing everything 100% right, Jack would have to be designated to represent the buyer also. He's going to guide and consult them on what they do with their offer. He's going to get confidential information. Matter of fact, everything he's doing is implying agency anyway. So we're going to do an agency disclosure. But outside of that, that's probably the only thing that Jack has in regards to the offer, any mention of it, because the only way that it's Jack's offer, and he helped Danny put it together, but his name doesn't need to be on the purchase agreement.
So
He would
Danny
put-
would sign it.
Well, Danny's not even going to sign it because unless if she witnesses the buyer's signature, right? Most of the time, because we're doing digital signatures,
Right.
we're not witnessing because we
Okay.
didn't witness the individual who actually pressed the button to
Exactly.
sign that. So Danny's name probably would only be in the first section of the offer where it says who's the buyer's agent.
Mhm.
Because Jack doesn't want anything to deal with it after he got it back to Danny and sent it off.
That could potentially lead to the loss of a client, though. Even though Jack is writing the offer for
Yep.
Danny, then that
Yep.
client may not get his offer or her offer accepted. So they may walk away feeling as though Danny didn't service them properly because she allowed Jack to
Mhm.
step in on her behalf. I mean, that there are all kind
Actually,
of possibilities,
Brenda,
right?
Brenda, I worried about that. And I
Mhm.
actually told Linda, I mean, that my client, that Val would be handling. I told her exactly why, and she understood 100%, and she was happy with that.
Well, transparency is everything, right, Danny?
Right. But I was nervous at first, thinking, oh my gosh, if I tell her that, she's gonna bail on me or not want me
Mhm.
to represent her in the future. And she really appreciated that.
Well, I'm not speaking so much like on the onset. I'm thinking, okay, you have Val in this situation stepping in on your behalf to present the offer, write the offer for your client. So if the offer that Val prepares for your client, his offer or her offer is not accepted, then that buyer client of yours could feel as though Valerie didn't represent them in a way that maybe you would have, that would have resulted in their offer being accepted, rather than the other offer being accepted. Those are all kinds of scenarios that just came to mind.
Yeah. Well, that's why I say you hope that you don't run into it. Legally, you are covered. You are covered through the contract, but that doesn't make it any easier when it actually occurs. And like I say, I had it one time. And the best benefit is I married another real estate agent. One of us wrote it for one, she wrote it for the other. Okay, good stuff. Good stuff. Well, guys, 20 minutes went by on the open discussion very quickly here. So it's past 1 hour for this one, but these guys are great. I love them when they come up. It creates a lot of discussion. Um, and so, Jason, I don't know why you're coming up here with a 2 on. Was anything that you needed there, buddy? All right. So, guys, I'll tell you, I didn't come up with this until 10 o'clock this morning when I sent that notice. So when we talk about it being a hot topic Tuesday, it's like, yep, I still look for the hot topic right up until. And so this became that open discussion with a definite plan, but it works out well. These are always fun. We'll do more of them. If you've got subjects that you think would be great, forward it to me and we'll get things going. So I appreciate you guys. You know, now there's a whole lot of people are out there. People are thinking of me making a move. So I'm going to say first be there and be good when you get there. And that means we got to go talk to a whole lot of people. See you soon. Have a great one.